Limiting freedom of speech by the government is highly controversial. Some countries restrict speech to keep order, where others have few limitations. In Thailand, it's against the law to insult their leader. Breaking this law could result in prison sentences of up to 15 years. In Germany, it's against the law to publicly deny the Holocaust. This can result in jail time. In Pakistan, laws make it illegal to insult Islamic practices. Consequences can be as severe as the death penalty. So where should the line be drawn? In the United States, the First Amendment of the Constitution states the right to freedom of speech. Over time, this right has been challenged in the Supreme Court. In 1919, the court ruled that freedom of speech protected by the First Amendment may be prohibited when it presents a clear and present danger, adding that they would not allow a person falsely shouting fire in a theater and causing a panic. In 1925, the precedent, rule to be used in future cases with similar circumstances, of clear and present danger was applied in another case, Gitlow v. New York. In 1919, a New York politician, Benjamin Gitlow, published an article called Left-Wing Manifesto in a socialist newspaper that he managed. For publishing this article, Gitlow was charged with violating New York's Anarchy Law of 1902. This meant that the government of New York thought the article encouraged people to overthrow the government. In court, Gitlow argued that he was within his First Amendment right to free speech and free press to express his own thoughts and opinions. He had not intended to encourage violence. He was tried and convicted in multiple appeals until the case made it all the way up to the U.S. Supreme Court. In the Supreme Court case, Gitlow had the same luck he had in lower courts. His charges were confirmed, as well as use of clear and present danger as reason to limit free speech. Benjamin Gitlow had the first case that the ACLU, or American Civil Liberties Union, argued before the Supreme Court. The ACLU is central to fighting for civil rights. They provide attorneys at no cost to people who need legal representation. They speak to members of Congress about issues, and they help all citizens become knowledgeable about their rights. Gitlow's case reinforced the idea of clear and present danger that limits free speech. This means that it could be restricted if it created an immediate threat. In 1969, though, the law changed. In Brandenburg v. Ohio, the court decided that speech must directly encourage imminent lawless action to restrict free speech. This established the Brandenburg test, which required that the courts prove the speech was used to bring about illegal activity and was also likely to cause the action to happen. So, how do the standards of clear and present danger and imminent lawless action set the stage for cases to come? Do you think the standards are fair to use when limiting freedom of speech? The question of free speech is a difficult and ever-changing issue, but by learning about our rights and the laws that protect them, we can be better informed and more empowered to make a difference in the world.